The complaint was from Sonke Tsinda Justice and the Democratic Governance and Rights Unit, complaining about the slow pace in the judicial transformation pertaining to gender discrimination in the appointment of judicial officers in South Africa. And the Gender Commission analyzed this, and they felt that whether they should investigate such a matter, and we came to a conclusion that the Commission for Gender Equality could investigate the matter.
The background to the investigation, as the Chair indicated, on the 12th of October 2012, DGRU and Sonke lodged a complaint with the CGE. The complaint pertains to the gender discrimination in the appointment of judicial officers in South Africa. It was submitted to the CGE that gender transformation in the judiciary has not progressed at a significant pace in consideration of Section 174 of the Constitution, which states that the appointment of judicial officers must reflect broadly the racial and gender composition. It has further been submitted that during the period of 2009 to 2012, the Judicial Services Commission interviewed a total of 211 candidates for 110 positions, and only 24 women were appointed. At the time the complaint was lodged, it was noted from the Law Society statistics of 2012 that there were more female law graduates than male, and more female admitted attorneys than male admitted attorneys. It was further noted that statistics from the GCB showed that there were 561 female practicing advocates nationally from a pool of 2,384. It has been widely reported that women are not adequately represented in the legal profession and in turn the judiciary within South Africa. Both the South Africa CEDAW periodic report and the non-governmental shadow report reflect the shortcomings. It is therefore recommended that the CGE, in consultation with the complainants and other key institutions, prepare a discussion document on the various factors that may hamper the progression of women lawyers within the legal profession as a whole. There should be engagements between the parties, being the CGE, Department of Justice and Correctional Services, the JSC and the Portfolio Committee on Justice and Correctional Services, and the Presidency, to convene a national summit to actively engage key stakeholders to discuss gender transformation in the judiciary and come up with practical resolutions and implementation plan on the matter. C, the State Attorney General should ensure that there is equal distribution of briefs to both men and women, with particular reference to black women attorneys. Additionally, it is recommended that government and the state-owned enterprises should insist that the instruction to the State Attorney that their briefs should include women. D, the private law firms must engage and encourage to adopt policies and practices which will ensure that there are equal distribution of briefs to women, with particular reference to black women attorneys and advocates. The Bar Council of the Republic of South Africa must be engaged and encouraged to adopt rules and practices which will ensure that women at the bar are briefed in matters involving senior counsel and in matters where senior counsel requires a second junior. The judge presidents and the deputy judge presidents of all the divisions must be engaged and encouraged to approach and attract women practitioners to act as judges and be preferred to their male counterparts in order to address the current imbalances. And lastly, the Judicial Services Commission must be engaged and encouraged to adopt a policy or criteria which will ensure that women will be appointed as full-time judges in order to address the current imbalances. Then in conclusion, the investigative report reaffirms that issues relating to gender transformation in the judiciary are very broad and sensitive. There is no clear cut in resolving the complaint before the CGE. It is axiomatic from the report that the appointment process of judicial officers involve a number of role players. This includes inter alia law societies, academia, voluntary associations that coexist with statutory bodies governing the legal profession itself, the JSC, the DOJ, as well. Thus, it will not be a correct approach to have one institution to take and accept responsibility of the paucity of women in the judiciary. Thank you.